Well, the judge didn't take much time in denying Chile's latest motion. If you haven't seen the motion, I suggest you go and watch Merv's video. But this one's probably worth a read. Judge Addison D. Burrows, electronic order entered. Plaintiff has moved for the fifth time for the court to retroactively find that his notice of voluntary dismissal, the notice, was filed before defendants answered his complaint, relying on the same arguments he raised in his previous filings. The only change this time is that he has moved under Rule 60A of the Federal Rules of Civil Procedure, which allows a court to correct a clerical mistake or a mistake arising from oversight or omission whenever one is found in a judgment order or other part of the record. As the court has explained in its prior orders, plaintiff has not pointed to any evidence that indicates that he actually filed his notice before defendants answered. First, although plaintiff claims to have filed the notice on November 6, 2022, there is no evidence that he did so. In fact, plaintiff himself acknowledged in an email exchange with the clerk of the court, which he appended to ECF number 58, that, even assuming he did attempt to file the notice on November 6th, it didn't work. Moreover, the search history, which plaintiff refers to as metadata, that plaintiff has repeatedly submitted to suggest that he attempted to file his notice on November 6, 2022, shows only that he visited the electronic filing website, not that he filed any papers with the court. Second, regarding the emails to opposing counsel that plaintiff contends support the findings that he dismissed his case before defendants answered, all the parties have been granted access to the court's electronic filing system and are registered ECF users, and Local Rule 5.4 (a) states that unless exempt or otherwise ordered by the court, all pleadings and other papers submitted to the court must be filed, signed and verified by electronic means as provided herein. In other words, for plaintiff's notice to have effect, he was required to file it on the docket via the court's electronic filing system, and as he acknowledged in his email to the clerk of the court on November 8, 2022, plaintiff had not filed anything on the court's electronic filing in the month of November. The court, therefore, denies plaintiff's motion, and plaintiff is ordered to not file additional motions seeking the same relief, relying on the same arguments that have been denied 5 times over. Should plaintiff file another motion on this topic, despite being ordered not to, the motion will be denied without further explanation. McManus Caitlin, entered November 30th, 2022. There you go. Thanks for watching.